Second reading.
Mr. Speaker, sir, I move that the Independent Broadcasting Authority Amendment Bill number 18 be read a second time. Mr. Speaker, sir, as the House is aware, the Independent Broadcasting Authority has been in operation for over 20 years now. During that period, only minor amendments had been made to the IBA Act of 2000, while during that same period, the media landscape has undergone considerable, if not dramatic, changes. It was therefore high time for the IBA Act to be revisited and revamped in the light of the experience acquired over the last 20 years. The aim is to adapt the law so that it can respond to present-day realities, exigencies and requirements, and to enhance the operational effectiveness as well as the efficiency of the authority in its regulatory role. Mr. Speaker, sir, the broadcast regulator has a vital role to play in our modern democratic society. And this role is to promote and maintain a peaceful broadcasting environment, and it does so by serving the best interests of all stakeholders in an independent, fair, and objective manner. It is therefore important for the legislation to be reviewed and tuned to present-day realities so as to enable the IBA to continue discharging its mandate effectively and efficiently in the new environment. Mr. Speaker, sir, the proposed amendments have been motivated only by the changes in the media landscape and past experience with the operation and application of the existing law. While proposing the new dispensation, as reflected in the bill, we have drawn inspiration from international best practices, which include an equitable balance between rights and obligations, between rights and duties, and between rights and responsibilities. Contrary to what is being ventilated in the media by some members of the opposition, the proposed amendments are certainly not an attempt to muzzle the private radios or to curtail freedom of expression in the country. The sole objective of the proposed amendments is to establish a modern and more comprehensive legal and regulatory framework within which the IBA can operate and carry out its functions and fulfill its obligations in a more effective and efficient manner. Mr. Speaker, sir, let me now explain briefly the salient features of this bill. Section 5.1 of the IBA Act presently provides that the authority may give written directions to any licensee, and the licensee shall comply with these directions. However, there is no specific mention to the effect that a breach of this particular section constitutes an offense. Therefore, with a view to reinforcing the regulatory powers of the authority, Clause 4 of the bill is amending Section 5 of the Principal Act to provide that any licensee who fails to comply with Section 5.1 of the Act shall commit an offense. Mr. Speaker, sir, Clause 4 of the bill is also amending Section 5 of the Act to empower the authority to impose administrative penalties for breach of the Act. Mr. Speaker, sir, as at date, the main sections that the authority can apply in case of breaches of the law are set out in Sections 24 and 25 of the IBA Act. Section 24 provides for revocation of a license, and Section 25 provides for the suspension of a license. The revocation of a license is an extreme measure, and it has been applied by the authority only once, and that was against Mayfair and Purely Communications Limited, which was commonly known as Planet FM. On the other hand, the suspension of a broadcasting license has been applied by the IBA on several occasions against all existing licensees. The fact remains that suspension and revocation of a license are harsh sanctions. We have therefore deemed it necessary to include administrative penalties, which, unlike suspension or revocation, will allow licensees to carry out their broadcasting activities. The imposition of administrative penalties is not new in our legal culture, and several regulators, including the Financial Services Commission and the Bank of Mauritius, are statutorily empowered to impose administrative penalties. Mr. Speaker, sir, I shall elaborate further on this issue of administrative penalties when I come to clause 9 of the bill, as a lot has been written and said about this new power which is being vested in the authority. Mr. Speaker, sir, clause 5 of the bill is adding a new section 18A to the Principal Act. This new section is empowering the director of the Independent Broadcasting Authority to apply to a judge in chambers for an order directing a person to disclose any evidence, communicate or produce any record, document or article needed by the authority in the exercise of its regulatory functions under the Act. It is important to highlight that a similar power is conferred on many regulators, including, but not limited to, the Dental and Medical Council. I here refer to Section 13(5) of the Medical and Dental Council Act. This power has been limited to the parameters of the Act, and the Director's application for disclosure will be subject to the judicial safeguard of an application before the judge in chambers. Honourable members on the other side of the House will agree with me that the judge in chambers will not grant an order on a mere request of the director of the authority, but the judge must be satisfied that the document requested relates to the exercise of the authority of its regulatory powers and is bona fide required by the authority in relation to the exercise of its powers under this Act. Mr. Speaker, sir, it is pertinent for me to mention here that in 2013, a private radio station was carrying out a sondage, and the authority asked for information in relation to that sondage, but the reply received from the radio was unsatisfactory. The authority resorted to the judge in chambers, but had to withdraw the case due to lack of legal basis to ask for information in relation to broadcasting operation of the licensee. The proposed new section 18A will thus enhance the powers of the authority, but such powers will remain subject to judicial scrutiny and control. I trust that members of the opposition are not implying that the judge in chambers will not be acting independently or will allow the director of the authority to make an application before the judge in chambers which does not satisfy the stringent requirements of Section 18A of the Act. Mr. Speaker, sir, Clause 7 of the bill is amending Section 22 of the Act to provide, inter alia, that a license for radio broadcasting shall henceforth be valid for a period of 1 year only instead of 3 years, as is the case presently. This provision is being proposed because radio licensees normally pay their license fees yearly. They do not pay their license fees for 3 years at one go, and this provision will put at par the duration of the license and the fee paid annually. The onus will be on the radio station to apply for the renewal of the license in due time. Moreover, on renewal of a license, the authority shall consider the past conduct of a licensee. This provision is similar to the procedure in a court of law, where the court has power to take into account the antecedent of a person before pronouncing a sentence. Mr. Speaker, sir, it should be noted that frequencies allocated to licensees constitute a scarce resource which is the property of the state. A license is not granted for life, and no licensee can claim any proprietary interest in the frequencies allocated to them by the ICT authority. The very word licensee refers to temporary nature of the permission granted to radio stations to use frequencies. Mr. Speaker, sir, Clause 8 of the bill is amending Section 23A of the Act by adding thereto a new subsection 3. Again, this new subsection will complement Section 23A of the IBA Act and will help the authority to enhance its regulatory powers in order to discharge its functions more effectively. Mr. Speaker, sir, Part 5 of the IBA Act currently provides for, inter alia, a standards committee and a complaints committee. Both committees have become obsolete and need to be replaced by a more effective mechanism. Consequently, Clause 9 of the bill is repealing Part 5 of the Principal Act and replacing it by a new Part 5 which provides, inter alia, for the procedures for the authority to impose administrative penalties and for the setting up of an independent broadcasting review panel to receive and adjudicate on a complaint by any person aggrieved by decision of the authority. Clause 9 further provides for the formalities, for the modalities for the operation of the review panel. Mr. Speaker, sir, let me come again to this issue of administrative penalty. The new Part 5 of the bill empowers the authority to impose administrative penalties on broadcast licensees. This specific power complements the panoply of sanctions available to the IBA. The principal objective of administrative penalties is to leverage and encourage compliance with regulatory requirements in order to protect viewers and listeners of broadcast licensees and to ensure the soundness of the broadcast industry in Mauritius. Responsiveness, proportionality, fairness and equity, deterrence, punishment, and reparation for damage caused are some of the necessary elements of an effective administrative penalty. In addition, administrative penalties, when imposed by way of an appropriate settlement mechanism subject to an agreement of the parties, will allow for the early and effective resolution of enforcement matters. Mr. Speaker, sir, this disciplinary measure is advantageous inasmuch as it caters for a range of administrative penalties depending on the seriousness and gravity of the breaches, and it will also act as a deterrent to licensees and encourage compliance with the IBA Act as well as the codes issued by the IBA. It is to be noted that the bill also makes provision for licensees to show cause as to why they should not be inflicted an administrative penalty, and in case the penalty is maintained, the licensees can apply for a review of the decision by the review panel. It should also be noted that the administrative penalty will apply to all broadcast licensees, including the Mauritius Broadcasting Corporation. In addition, the further safeguard of applying for judicial review in relation to a decision of the review panel has been provided for in the bill. Mr. Speaker, sir, although the imposition of administrative penalties will be a new sanction to regulate broadcast licensees in Mauritius, this practice is already well anchored in regulatory bodies in Mauritius, such as the Financial Services Commission and the Bank of Mauritius. This practice is also well established in foreign jurisdictions, such as the United States of America, the United Kingdom, and France. For instance, in France, the Conseil supérieur de l'audiovisuel, CSA, provides as follows, and I quote, les sanctions pécuniaires, le montant de la sanction pécuniaire dépend de la gravité des manquements commis et est en relation avec les avantages tirés de celui-ci. Il n'excédera pas 3% du chiffre d'affaires hors taxes réalisé au cours du dernier exercice clos calculé sur une période de 12 mois. Ce maximum est porté à 5% en cas de nouvelle violation de la même obligation. Lorsque le manquement est constitutif d'une infraction pénale, le montant de la sanction pécuniaire ne peut excéder celui prévu par l'amende pénale. Lorsque le CSA a prononcé une sanction pécuniaire devenue définitive, avant que le juge pénal ait statué définitivement sur les mêmes faits ou des faits connexes, celui-ci peut ordonner que la sanction pécuniaire s'impute sur l'amende qu'il prononce. Sont agrégés au montant du chiffre d'affaires l'ensemble des recettes publicitaires provenant de l'activité du service. Les sanctions pécuniaires sont recouvrées comme les créances de l'État étranger à l'impôt et au domaine. Unquote. In the United States of America, the Federal Communications Commission, FCC, provides as follows, and I quote, obscenity, indecency, and profanity. It is a violation of federal law to air obscene programming at any time. It is also a violation of federal law to broadcast indecent or profane programming during certain hours. The Federal Communications Commission defines indecent speech as material that, in context, depicts or describes sexual or excretory organs or activities in terms patently offensive as measured by contemporary community standards for the broadcast medium. Congress has given the FCC the responsibility for administratively enforcing the law that governs these types of broadcast. The FCC has authority to issue civil monetary penalties, revoke a license, or deny a renewal application. The FCC vigorously enforces this law where we find violations. In addition, the United States Department of Justice has authority to pursue criminal violations. Violators of the law, if convicted in a federal district court, are subject to criminal fines and or imprisonment for not more than 2 years, unquote. Similarly, in the UK, the Office of Communications, commonly known as Ofcom, which is the UK's broadcasting regulatory body, may impose a sanction if it considers that a broadcaster has seriously, deliberately, repeatedly, or recklessly breached one of its requirements. Sanctions may include a direction not to repeat content, a direction to broadcast a correction or a statement of Ofcom's findings, financial penalties, and depending on the license type and type of breach, shortening, suspending, or revoking a license. I am informed that in August 2021, Ofcom has fined a Chinese state-owned broadcaster £200,000 for failing to comply with broadcasting rules. Mr. Speaker, sir, the procedure to impose an administrative penalty has been clearly set out in Clause 9 of the bill. Same is in line with provisions of the Financial Services Act. Mr. Speaker, sir, as I indicated earlier, the Standards Committee and the Complaints Committee are being repealed and replaced by a new and more effective mechanism. I am informed that the last meeting of the Standards Committee was held in March 2013. Since April 2013, the Standards Committee has not held any meeting at all and has been ineffective in terms of output. The board of the IBA has considered the issue and at its meeting of February 2020 decided that membership of the Standards Committee be discontinued with immediate effect. From April 2013 to 27th of February 2020, an amount of 1,245,240 rupees has been paid to members of a committee which no longer had its raison d'être. It was therefore high time to review Part 5 of the Act in order to address this situation. In regard to the Complaints Committee, which is set up by the authority under Section 30 of the IBA Act, the members thereof are appointed by the authority. The Complaints Committee was set up in 2001. From 2003 to date, the Complaints Committee has dealt with 228 complaints falling within its jurisdiction, as provided under Section 34 of the IBA Act. Mr. Speaker, sir, there have been instances where complaints have been lodged before the Complaints Committee, and at the same time, the complainant has lodged a case before the appropriate court and has made a declaration to the police. In such circumstances, the Complaints Committee has set aside a number of cases on application of Section 36A of the IBA Act. Out of the 228 cases received by the Complaints Committee, 117 cases have been set aside from 2003 to date, including those under Section 36A of the IBA Act. Mr. Speaker, sir, as the law stands now, after considering a complaint under Section 30, subsection 4 of the IBA Act, the Complaints Committee is required to forward a copy of its decision to the authority, pursuant to Section 30, subsection 10 and subsection 11 of the Act. It is the authority which has the power to approve the recommendations of the Complaints Committee, and same is communicated to the parties. It is only then that the decision becomes a final decision. The bill now provides that a public complaint will be referred to the authority by the director. This will help to speed up matters and will save cost and is in the interest of all parties. Mr. Speaker, sir, the bill proposes the creation of an independent broadcasting review panel which shall consist of a chairperson who shall be a barrister at law of not less than 5 years standing and 2 members having wide experience in the field of broadcasting policy and media issues. The review panel shall inter alia regulate its proceedings as it may determine and shall ensure that proceedings are conducted in a manner which is consistent with the rules of natural justice and procedural fairness. The review panel will have the power to deal with complaints from aggrieved licensees in relation to the administrative penalty imposed. In case a party is dissatisfied with the decision of the review panel, the latter may have recourse to judicial review of the decision of the review panel before the Supreme Court. Mr. Speaker, sir, I must point out that the review panel proposed in the new Part 5 of the bill is based on similar provisions in the Financial Services Act and the Bank of Mauritius Act. Mr. Speaker, sir, clauses 15 and 16 of the bill are amending sections 37 and 38 respectively of the Principal Act to increase fine for offences from 100,000 rupees to 500,000 rupees and a term of imprisonment from up to 2 years to up to 5 years. Mr. Speaker, sir, it must be highlighted that up to now there has been no person who has been caught under Section 37 or 38 of the IBA Act. In any case, if there is any matter pending before the court, an application of la peine la plus douce principle under Section 10(4) of the Constitution, the lighter penalty will apply. Mr. Speaker, sir, Clause 19 provides for the chairperson of the Independent Broadcasting Authority to sit on the board of the Information and Communication Technologies Authority. The objective is to allow better synergy between the Independent Broadcasting Authority and the Information and Communication Technologies Authority in relation to issues of broadcasting. The services provided by the ICT Authority are complementary to broadcast regulation, given the blurred lines between the ICT and broadcasting. For instance, the ICT Authority manages frequency spectrum, and broadcasting cannot be done without frequencies. For this reason, since its enactment in 2000, the IBA Act provided for the chairperson of the ICT Authority to be a member of the IBA board. However, the ICT Act does not provide for the chairperson of the IBA to be a member of the ICT Authority. Therefore, the composition of the ICT Authority as set out in the ICT Act is being amended to provide that the chairperson of the IBA shall be a member of the ICT Authority, thus allowing more synergy between the IBA and the ICTA in relation to broadcasting frequencies allocated to licensees. Mr. Speaker, sir, it is a fact of life that in all human activities there must be movement forward. Our legislation too, if not some of it, also needs to move forward with time, but with justification. In the present case, our experience has been the chief philosopher. Mr. Speaker, sir, to conclude, the IBA has in the past often been described as a bulldog sans dents because of its limited regulatory powers, and it is the right time for the authority to find and show its teeth. The Independent Broadcasting Authority Amendment Bill 2021 provides the best fit under these circumstances, as it will surely empower the IBA to meet the future regulatory challenges for the benefit of the country, and it will also pave the way for the highest standards of broadcasting in a fast-changing landscape, guided by democratic principles. With these words, Mr. Speaker, sir, I commend the bill to the House.
At this stage, I'll be suspending the sitting for 45 minutes.